Welcome to Rebel Chaser. My name is Gail, and I've got two videos for you today. The first one is with Judge Hesselink at Otsego, and then the second one is also Otsego, but I think that's how you say Otsego, but I don't know what his name is, so I'll just let you guys watch.
All right. Court will recall the matter of James Dash versus Rebecca Degrez. It's file 25-40752-LT. See that Mr. Blumberg is back. Do we have Ms. Degrez with us?
Hello.
Ms. Degrez is with us as well. Mr. Blumberg, are you able to stay with us for a while now?
I am, Judge. Thank you. I appreciate your courtesy.
All right. The case is with you to start, and then we'll hear from Ms. Degrez afterwards. How do you wish to proceed?
Judge, Mr. Dash, I think appearing via Zoom as well. I think he's muted.
Mr. Dash, are you with us? If so, I need to see your video on and your audio available.
Yeah, I'm here.
Need to see your video, sir.
Can you see me?
I can. Thank you very much. All right, Mr. Blumberg, go ahead.
Judge, let me, if I may, just take a moment to give you an overview of where we're at in this matter. Mr. Grace is the mother of my client's child. In the midst of a custody dispute and parenting time debate, the parties came to an agreement whereby Ms. Degrez would be able to remain in the residence owned by my client, and that is at Seagoland Drive, Gaylord, Michigan. She was allowed to stay there for a period of time with the understanding that at the end of March of this year, she was to vacate the premises. That was memorialized in a mediation agreement between the parties and signed by the parties and their respective counsel. In consideration of that, certain monies were to be deducted from Mr. Dash's child support obligation. Well, March came and went, and Ms. Degrez has remained in that property since then. She's been served properly with a notice to quit and a complaint to recover possession of property. Her defense is, as I read it, or at least as I hear it, is that she's a single mother and she has no place to go, and there were other conditions that she believed would somehow allow her to stay in the property. The reality is that she has no legal right to remain there. She's been a holdover tenant since March 31st, and we are simply seeking the court to enter an order to recover the property for my client. Mr. Dash is here today, if necessary, to testify to those things that I've just represented to the court.
All right. Ms. Degrez, do you disagree with anything that Mr. Blumberg has said?
I would dispute.
You have to talk a little bit louder so I can hear you, ma'am.
I apologize. I would in fact dispute that almost everything he said and the eviction itself.
Is there an agreement between the two of you for you to be out at a certain date?
Yes, sir. If I may provide background as well, just briefly. I am the primary caregiver, sole caregiver of our shared minor son, Colton, and I have maintained the stable residence at Seagoland Drive since November 2019. We did enter a mediation agreement that was dated August 1st, 2024.
Ma'am, every time you look to the side, I don't have the ability to hear you then. So you either need to move the paperwork closer to the microphone or change something somehow so I can hear you.
Yes, sir. I do apologize. The plaintiff and I did enter into a mediation agreement, which was dated August 1st, 2024. There were specific terms in that agreement that do apply directly to our situation now. First was conditions related to payment of the arrears by the plaintiff, which was conditional then on my move out. There were additional financial and logistic responsibilities, as well as within the mediation agreement, there's a mutually agreed upon review to revisit mediation before summer 2025. I did make several attempts with community mediation services. They did reach out to James and Mr. Bloomberg, and my attempts for further mediation were denied. There was no final eviction or move out date unless said conditions were fulfilled in good faith. And there's more. There was no official lease. It was just the date in the mediation agreement. There was no official agreed upon terms outside of that date, with the various conditional matters I had already stated. Additionally, Mr. Dash did unlawfully lock me out on March 18th, 2024, violation of MCL law 600.2918. I do have video proof from the Michigan State Police, 2 10-minute videos with Trooper Hop of Mr. Dash changing the locks on Colton and I, and not allowing us back in.
What was the date on that? What was the date of that?
March 18th, 2024. So this would have been just as like within process of trying to get the PPO.
Of 24 or 25?
24.
So that would have been before the lease agreement or the mediation agreement, I mean?
Yes, and there was no, I asked for a lease. I was never given a lease.
So the illegal lockout, you say that there wasn't a lease agreement. How did he illegally lock you out if there was no lease agreement?
So this was documented in the PPO. Not resistance. When he had disputed the PPO, there was like a 3-hour court we had with Honorary Judge Mertz, and so this has all been documented. I would think well documented.
I'm not disputing the documentation, but the question I have is how would it violate the landlord-tenant law if there was no lease agreement and this happened prior to the mediation agreement?
Due to domestic situations at the time, Cole and I were living there by ourselves, and Mr. Dash had become very threatening. So I left the house for the night to go to my mother's. And then when I returned the next day to try to get Colton's things, he had locked us out. And so I had requested police assistance out of Pier, and they did record that interaction. That was Trooper Hop. So there's never been a lease in place is what I'm saying. And I've definitely tried, but I believe it's always illegal to change the locks on someone's place of residence, which it was clearly mine established since November 2019.
All right, but then you stayed with him for the end of March, April, May, June, July, and then August before the mediation agreement, right?
No, sir. Mr. Dash was not present at the home after a domestic incident in August. And
so up to that point, were you residing together?
Up until August 2023, yes. Until that reported domestic incident, we were. Yep. Mm-hmm.
So you're alleging that he changed the locks in March of 24?
That is correct, sir.
Then you reached a mediation agreement in August of 24.
Mm-hmm.
All right. I just wanted to make sure that I understood your timeline. Thank you.
Okay, I have more in case you need more.
Well, let's take your statements one at a time. Mr. Blumberg has said that there was a mediation agreement, and it appears that you agree with that. And I'm looking at it. It's dated Thursday, August 1st of 2024. Mm-hmm. And it does say down near the last paragraph, the opening sentence says, both parties agree that Rebecca will stay in the home owned by James until March 31st, 2025. Am I quoting that correctly?
That is correct, sir. Based on the conditions.
You are alleging that there are some caveats to that, some conditions on that?
Absolutely, and other illegal bad faith things.
I'm sorry, I didn't hear what you said.
I apologize for interrupting.
No, you're fine.
I said as well as further actions by the plaintiff that I would consider illegal and against, like, the
All right,
eviction
so
in general. The date.
let me take these things one at a time then, so I can understand them in order.
Okay.
What is your first reason for believing that there's an additional condition in play? Start with your first one, and we'll take them in order.
Okay. And just one little bit of background. The mediation did go for hours.
I'm again having a hard time hearing you, ma'am.
I'm so sorry. I keep trying to speak up. It could be my computer as well. I do struggle with Zoom. So during the mediation agreement, it did go on for hours. I was under like severe emotional and mental duress, and I did agree because I felt I had no other choice.
Judge, I object. First of all, as you well know, what goes on at mediation is confidential. The mediation agreement reflects the agreement of the parties and their attorney. She was represented by counsel at the mediation. So any discussions about what went on in mediation, I believe, is improper.
All right, ma'am, counsel is correct. An agreement is an agreement. It really doesn't matter how it got there or when it got there or under what circumstances it got there. This is an agreement. It appears to me that it was, has this been entered in a court order that solidified this? I assume in the custody proceedings?
Yes, Judge, it has.
Ms. Degrez, do you agree with that this has been solemnized by a court order so that it's a binding agreement on the parties?
Yes, sir. I have the dates here as well. It was with Honorary Judge Mertz. I would just like to add, though, if just given the context,
all right, so
matters and like that the threat, like I felt very threatened. I still do.
Ma'am, whether you felt threatened or not isn't going to change anything. If this is a court's order out of this mediation agreement, it is what it is. Whether you agree to it willingly or unwillingly or under duress or whatever, I can't change that now. All I can do is enforce what it says. So both parties have agreed that there was a mediation agreement. Both parties have agreed today that this has been put in place under a court's order in the custody and parenting time case. So I need to know whether or not there are these conditions that you allege to this agreement. So the agreement says in one sentence that you're supposed to be out by March the 31st. What do you believe allows you to stay after that? What are the conditions that you outline? So lay them out for me and we can take them one by one. So what's your first condition?
Yes, sir. There was no lease given to myself.
Ma'am, I'm sorry, but every time you turn your head, I cannot hear you. So if you want to have me hear you, you have to face the camera and speak directly into the microphone.
Okay, I'm so sorry. I just get a little nervous. So I think foremost, there was no official lease telling me any further terms. In a lease situation, there's usually like a month to month that happens, and that would just be like the very tip of the iceberg. Is there not being a lease, me asking for a lease, not being provided with one, and repeatedly like trying to go through community mediation. So I'm not even sitting in front of yourself right now. So that would be the first, no lease. There's several things that
So the first one is no lease. Mr. Blumberg, your response to that?
Judge, there didn't need to be a lease. It was a verbal agreement reduced to writing that allowed her to stay in the home until March 31st of 2025. Any other terms in terms of who was paying the utilities, none of that was an issue or a factor in her ability to stay there. And again, there were no conditions. If the court reads this mediation agreement, there's no language in there that says the right to stay in the property is conditioned upon Mr. Dash complying with all other terms. Because if that's the road where she's going down, the fact is she has been the one that's denied my client parenting time, which was granted by the mediation agreement. Well, so there didn't need to be.
I'm not here to. Sorry to interrupt, but I'm not here to do parenting time. This is a landlord-tenant matter. That's A different court, that's a different proceeding. So the issue is whether or not the fact that there was no written lease allows her, or is a condition, would allow as a condition for her to stay longer. I know of no legal precedent that would say that that is true, ma'am. The fact that there was no written lease may have enforcement consequences as far as him requiring you to pay rent, but I don't know of anything that says that you get to stay longer without his permission. And clearly he has revoked that permission at this point. So I don't know of any legal requirement that says that you are allowed to stay other than by the party's own agreement after you've reached an agreement that says you are to be out on a certain date. So I'm going to deny that as a basis for allowing you to continue to stay. What is your second reason that you believe would allow you to stay longer than March the 5th, March 31st?
Okay, very good. So I do disagree with Mr. Blumberg. Verbally within that mediation, it was known or agreed that the payment of the arrears was how I was going to move out of the house as well. Like, it's pretty conditional on it.
So the second basis is that you believe that he had to repay child support arrears in order for you to be required to move out of the home. Is that
Yes,
correct?
sir. And yes, sir. I do have documentation of all the payments, which I've submitted. I think Mr. Blumberg does as well, but I've never seen James' documentation of the payments, so I'm not aware the truthfulness of what was submitted. Yes. So as I took it, the move out date was based on his fulfillment of said obligations. He failed to pay, he failed to mediate, and he acted unilaterally against several court matters, his own lawyer, myself,
Okay.
good faith. Yes.
All right, so hang on. Let's not get too far ahead of ourselves. So the second reason that you would think you should be allowed to stay is that he failed to pay the arrears that are referred to in the same paragraph, where it says Rebecca agrees that there will be a monthly rent of $1,500 beginning the first of the month following the child support arrears being paid in full. Rebecca agrees that the rent money can be credited toward the child support beginning the first of the month of the child support arrears being paid in full. And then James and Rebecca will provide receipts of payments as a credit since March of 2024 to both attorneys on the child support in arrears. So you believe that those three sentences together give you a condition that says that you can stay until he pays off the arrears. Is that what you're arguing?
Yes, sir. I'm so sorry. I would have liked the mediation agreement, that paperwork to have fleshed that out more clearly for me, just as I had asked several times for a lease, so I understood all of the terms,
No,
and I was never
I
provided.
can't change it now. All I can do is try to give effect to
Oh,
what it
yeah.
says. So
Okay.
that's the three sentences that you want me to consider on your argument. Is that correct? That's what you think says that you can stay there longer if he doesn't pay the child support arrears.
That's what it says. So, yes.
All right, Mr. Blumberg, your response to that?
Well, two things. I don't believe it says that. And more importantly, he has paid all the arrears. There is no child support arrearage at the current time.
And how do I know that?
Well, Judge, that's a custody and parenting time issue that you're not going to be addressing today. So I can assure the court that the front of the court would be filing motions against Mr. Dash if he was in arrears.
They have.
All right.
There's several motions. There's 61 items.
All right. Here's the language says that there will be monthly rent of $1,500 beginning the first of the month following the child support arrears being paid in full. From this document alone, I can't tell when payment of rent was supposed to start. It would be some point in the future from the date of this agreement. whenever the child support was paid in full.
Yes, when the arrears were paid
And
in
that's-
full was when that would start. There is no
Okay, so
payment
that's-
on the house as well. The house is paid off. That's an important detail. Yeah,
So-
there's no
What
payment
to
on the
do
house.
with it?
All right,
The
hang
mortgage
on.
is paid.
All right, stop. Let me process it. The next sentence says that Rebecca agrees that the rent money, when paid in the future, can be credited toward the child support beginning the first of the month of the child support arrears being paid in full. So there's another in the future thing gonna happen. So rents in the future, rent being being placed towards or credited towards child support is in the future, again, after child support is paid or the arrears is paid in full. And then the only other sentence that's there says that Rebecca and James will provide receipts of payments as a credit for what has been paid since March of 2024. So something in the past. So I got two sentences that deal with something in the future, and I got a sentence that says something in the past, and we're going to try to work all of this out about the arrears. It doesn't say anything about condition on when you are to move out of the house. It is rent for while you are staying there. Which would start in the future if the arrears are paid off. I assume if the arrears are not paid off, you would never owe rent. And all it is, all that language is conditioned on arrears being paid first. But if it is, then you owe rent. If it's not, you don't owe rent. It's got nothing to do with how long you stay in the house.
Okay.
Okay, so I can't find any reason for payment of arrears to be allowing you to stay within the home. Okay, so your next allegation of a condition is that you said he failed to mediate as to parenting time. Is that correct?
Well, that in the matter of the house.
I'm sorry, that in the matter of what?
The house, that and the matter of the house. That was to be discussed in mediation.
What about the
It's
house
not-
is to be discussed in future mediation?
Um,
What about the house was supposed to be discussed
sorry.
in future mediation?
Our shared minor child and I staying longer than the date in the mediation agreement was to be discussed in the mediation.
Where does it say that where does it say that that's going to be further mediated?
It does not, sir. I would have liked it to be included, but I don't have control.
Well, you did at the time of mediation. You could have put that in there, but you didn't. So that's what I'm asking you. But did I miss something? I don't see it within this mediation agreement that you're going to come back and do future mediation on how long you get to stay in the house. Can you point that out to me, or is it not there?
It is not there, sir. You're correct. It would have been nice to have an addendum on that sentence that said, and as well as the house.
All right. Well, all I can do is enforce the agreement as it's written. So
Yes, sir.
I'll have to deny your request based on the failure to mediate on the house because it's not within the document, and it doesn't appear to me to be a reasonable reading of what the document says to imply that or to infer that at this point either, because future mediation is stated previously, I believe, 4 paragraphs above that. James will have 6 weeks of parenting time commencing in the summer of 2025. If the parties cannot agree on the schedule, they agree to return to mediation. So there is a paragraph in there that talks about returning on a specific item. So you could have put that in there about the length of time you were going to stay in the home, and that wasn't done there. Is there any other condition that you have that you believe allows you to stay within the home?
Yes, sir. I do.
Go ahead.
I may proceed. So the unlawful lockout of 3/18/24, of which I have trooper video from, is that not relevant?
Okay, so the lockout
Legal
of
action?
March 18th of 24,
Mhm.
which is approximately 4.5 months before this mediation agreement, why would that allow you to stay longer than so you had the lockout in March, you have the mediation agreement in August of 24. why would that extend the period for you to stay that you reached in mediation in August? Why would a March event change an August agreement? I'm sorry, ma'am, I can't hear you. I still can't hear you for whatever reason.
I don't know if it's the microphone or here, let me pull that out.
If you're close enough, I get you, but as soon as you back
Okay.
up a little, I can't hear you.
I just don't want you to see my whole face. So, okay, here we go.
Your whole face is just fine. I don't have a problem looking at your face, so you're good. I just need to hear you because it's important.
Okay. Yes, very good, sir. So feel free to interrupt me. I would like to respond to that.
Go ahead. Yep.
This is just one item that reflects a pattern of control that the plaintiff has exercised over myself for over a decade. There was a criminal case that was pending that was led to a plea deal just this past week, and additional humiliation on my part.
Judge, I'm going to object to this. It has nothing to do with the landlord tenancy
I'll
matter.
get there.
Excuse me.
I'm getting there.
Let me just finish.
Ms. Degrez, hang on, both parties, hang on. Let me explain it to her. Ms. Degrez, Mr. Blumberg has the right as an attorney to object to an argument or a statement that the other side makes. So he's made an objection. I'm then going to come to you and you're going to tell me where it is that you're going with this argument, and then I'll rule on whether or not it's going to be allowed. So he says that your argument that decades worth of alleged bad behavior on Mr. Dash's part isn't relevant to this agreement. So I want you to tell me why you think it is.
Myself, yes, me.
I'm asking you that. Yes, go ahead.
Okay.
Tell me why it should be. I should consider it.
Okay, I believe this attempted eviction is a clear act of retaliation and harassment intended to punish me for any testimony that I would have put in for the case that was just decided this past week, continually undermine my stability and safety, and coerce me into silence. The threats placed on both myself and our shared minor child put us at severe risk of homelessness. Our child will lose shelter, safety, schooling, community, access to care. We're very well established in the community. I work at the high school. So this constitutes child endangerment on Mr. Dash's part for forcing an eviction for his minor child that very much doesn't want to move. Under Michigan law, MCL 722.622. So I consider this to be like a retaliatory eviction and leading to child endangerment.
Okay.
I have more as well.
But the idea behind all, you want to explain in a little more detail as to what he's done to you that causes you to believe it was a retaliatory eviction. Is that correct?
I can do that.
I just want to make sure I understand your argument first. So Mr. Blumberg has objected. You've said you believe it to be a retaliatory eviction. I'm going to give you the opportunity to tell me quickly, but I am going to give you the opportunity to tell me why you believe that this is a retaliatory eviction. Go ahead.
There's been a long pattern of threats and documented 911 calls from situations with Mr. Dash. I've continually felt threatened by both himself and his counsel. There was a letter sent by Mr. Blumberg to the state police, the county police, that I was not even supposed to be allowed in my home until the PPO was upheld by honorary Judge Mertz. So I have felt threatened all along, and there is documentation of it, including the lengthy PPO hearing that we had that supports that. Let's see, I have more. I do feel like it's a violation of my rights as a tenant, as a mother, and a survivor, and I'm just asking for continuity of housing for Colton and I, or even for the parties to agree to revisit this matter in mediation. I would really just like to talk it out, not in this setting. Or an extension. Our son really just doesn't want to move.
Anything else that you want me to be aware of regarding this claim of retaliatory eviction?
Just give me 1 second so I can look over my notes.
Again, ma'am, you're too far away from the microphone. I can't hear you.
Just give me 1 second so I can look over my notes.
Yep, go ahead.
Fulfillment of obligations, arrears, engagement, mediation, sales of plea, child endangerment. Oh, I feel that the threats are retaliatory based on my reporting of these incidents. Like I said, there's multiple calls, documentation with both state troopers and county police. And I feel like it is also retaliation for my cooperation and respect for the legal system and for law enforcement. To my knowledge, like it would constitute grounds for court protection, which I currently have in a no contact order, not for eviction.
Right. Is there anything else that you want to tell me about regarding the retaliatory eviction?
No.
All right, Mr. Blumberg, your response to that.
Judge, this is hardly a retaliatory eviction. This is a date in which she agreed to vacate the premises. She has been there improperly as a holdover tenant since March, April, May, June. Here we are in July, and she still refuses to vacate the property and assert some ridiculous claim of retaliatory eviction and child endangerment. The fact is she was a guest in my client's home up until the time where they separated. And when we entered into this agreement, the parties agreed she would stay until March 31st. That's why my client is seeking to regain possession. She has no legal right to be there at this point. We would ask the court to disregard any claim of retaliatory eviction.
All right. Ma'am, I can certainly understand emotionally why you would believe that you are being threatened or that you have in the past been threatened. I can certainly understand why it would be emotionally difficult for you to leave the home and why your son would not necessarily want to leave the home. But I find no legal basis for believing that this is a retaliatory eviction. The date noted in the mediation agreement and subsequently affirmed by the court's order was that you were to stay in the home owned by James until March 31st of 2025, which means that after that time, he has a proper legal basis for asking that you be, in essence, be evicted. He has taken advantage of that. There is no indication on this record that he has, by filing this action, that he has violated some other law or some other court order. I've not heard or seen any indication that the custody or parenting time order has been violated or that the personal protection order has been violated by this request. The request is a normal, legal landlord-tenant law request. It's not, he didn't self-help. My original thought when you first brought up the lockout was that was in March of 2025 and that this was somehow a self-help cause of action and that you were objecting to that. So I see no action by either Mr. Blumberg or by Mr. Dash that is retaliatory. They are simply using the court system to enforce a legal right that you agreed to when you reached the mediation agreement and that the court affirmed when it entered the court's order in a custody and parenting time thereafter. For that agreement to have any effect, the court has to be able to enforce it. And the court, the mediation agreement and the court order very clearly says that you were to stay in the home until a specified date. You have now exceeded that by a number of months. It was supposed to be March, the end of March this year, so April, May, June, and now we're through the first week of July. You have exceeded that time period. So I'm going to deny that as a reason for allowing you to stay further within the home. Do you have any additional conditions that you believe would allow you to stay within the home outside this mediation agreement?
Did you then, did you refuse the child endangerment situation with him then forcing his minor child to be homeless?
The statute that you cite, MCL 722.622, is the child protection statute, and it basically is the definitional section. It does
Yes.
not contain. It does not contain a specified definition of child. There are certainly definitions of neglect, serious abuse, all of those kinds of things. But the only statute that I'm aware of in the state of Michigan is drunk driving with a child less than 16 years of age in your car. That's called child endangerment under the Michigan statutory scheme. I understand what you're saying, that by kicking your son out of the house at or without you having another place to go might be some sort of in your mind, but I don't find that as a matter of fact today, because I don't know under what circumstances you would be able to move the child. And if you are the parent, as you've alleged, if you are the parent with custody at the moment, where the child is going to stay would fall on you first, even if you were. So if this was a third party that was saying, hey, you haven't paid your rent, I'm going to kick you out, it's not abuse for that landlord, whoever that landlord would be, to remove you from the home. Even if you were to be homeless at that point, it would be your job to find the child immediate shelter. And if so, I can't make a finding of fact that says that his use of the court system to enforce a right that he has is child endangerment, because it's not a statutory phrase or a violation. I also find that it's not neglect or abuse under these exact circumstances as I have them today, because you are able to provide. Even if he was to kick you both out, he knows that you are able to provide for the child's immediate safety and find the child an appropriate place to stay immediately thereafter. So I don't find that that is a proper basis for action to extend the time period for today. Is there any other condition that you would propose?
May I just point out a specific law?
Go right ahead.
750.161. And you, I hear you. I understand what you're saying. In section 161 of that, in reference to Mr. Dash, a person who, being of sufficient ability, fails, neglects, or refuses to provide necessary and proper shelter, food, care, and clothing for his or her spouse or his or her children under 17 years of age, is guilty of a felony, punishable by imprisonment, etc. He meets all of these things. Like, he has not provided necessary shelter, food, care, clothing. Yes, just to give you, because you had said, and you are correct, that's just like a very simple, like stating what the law is, the first one I named, but this one kind of fleshes that out a little bit more. But I do accept as well what you are saying. I do not feel like we can look at this from an objective perspective as this just my landlord. This was our family home. We worked for together, paid it off together. There's no mortgage payment on the house. And I'm trying to advocate for myself and my son.
I don't have a problem with you advocating.
I do not.
I don't have a problem, ma'am. Ma'am, hang on. Oh. I don't have a problem with you advocating for yourself and your son, and I think you're doing an admirable job. So that's not an issue. The issue is, that's all that's in front of me today is landlord-tenant. Does a landlord have the right to remove a tenant when there's an agreement between the landlord and tenant to move at a certain date? And the answer to that question is yes, he does. And simply by removing the tenant, if the tenant has a young child, does not cause the child to be neglected, because the tenant can provide for the child's immediate welfare by getting a motel or getting a hotel or going to a homeless shelter or renting another place. So it is not abusive or neglectful, even if the landlord is the father of the child and knows that the child is going to be removed from the home that the child believes is its long-term home. That may have some emotional impact on the child, but by and of itself, I do not believe that it is neglectful to the point where it would overcome the landlord-tenant laws. If you disagree with me, you may certainly report it to Child Protective Services. They may do an investigation, and if they believe that I am incorrect, they can bring that by way of a child protective proceeding in court, and I would review it again at that point. But as of today, the landlord simply enforcing an agreement reached with the tenant for a date to be removed from the home does not amount to abuse and neglect. Do you have any other conditions that you believe would allow you to stay within the home longer than the date that you agreed to?
Let me just look. They are rather backed up at CPS too. They're very busy over there.
I deal with them every day, so I know exactly how busy they are.
I know.
Correct. So
they really are. They're doing the good work.
Judge,
right.
Can I respond while she's looking whatever it is she wants
Yes, sir.
to? If anyone is neglectful in this situation, it is Miss Degrez. She is the individual who cannot provide for her child. My client, at a moment's notice, can provide this child with housing, food, and clothing. So if she wants to go down that road, she is the neglectful parent, not my
Love to
client.
go down that road. Sir, I would love to go down that road. Like what, 230 miles away? 230 miles away,
Stop.
sir.
Ma'am,
Sir, the false
as I've
narrative
said,
and the humiliation is not acceptable.
ma'am,
I'm sorry.
as I've said before, I'm not going to consider what Mr. Blumberg said because I'm not here on abuse and neglect. I'm not here on custody and parenting time. I'm not here on any of that. This is landlord tenant. I don't take what Mr. Blumberg said as a statement of fact. He's an advocate for his client, and that's all that was there for. So please review your notes, do whatever you need to do, take a minute to think about what you need to do. And then all I need to know is, do you have any other reason for believing that you can stay longer than March the 31st in the home?
I'm reviewing.
Go right ahead.
Okay. I guess they have a closing or yes, I can talk. Very good.
Go right ahead.
I would request the court not to think of this situation as a contractual dispute. It is a matter of child safety, survivor protection, and a parent's right to remain housed while completing a master's degree and caring for our shared son. The plaintiff's actions are consistent with the long-standard pattern of abuse and retaliation, and this should be evaluated as such in any legal setting, especially as it pertains exactly to this. I don't believe it can be looked at objectively as a landlord-tenant typical situation that you described. I do understand what you have said. I agree with this very much. I would like the court to consider the non-performance and retaliatory motives of the respondent with this. And please just uphold my continued right to reside at my home at minimum until a mediation session can be held and we can agree on further terms. It's in the best interest of our child. But again, like you said, I realize this is not a custody dispute. From my perspective, I felt like it was in bad faith the arrears weren't paid, and that was verbally discussed, agreed upon. And it is to my detriment that it's not an addendum within the mediation agreement. I did request an addendum to the mediation agreement in January as well, and I have been denied continually. That is all, sir.
All right. Mr. Blumberg, do you want any response?
Just briefly, Judge, and I'll try to stay on point. Contrary to what Mr. Degrez says, this is a contractual situation. There was an agreement freely and voluntarily entered into by the parties. It specifically gave Ms. Degrez the ability to reside in that place until March 31st of 2025. In spite of our numerous requests to peaceably ask her to leave, she refused to do so. And we had no choice but to bring this action, seeking the court ordering her removal from the property and retaining possession to my client, the rightful owner. This isn't about custody. It's not about child endangerment. It's about my client's legal right to retain his property. Thank you.
All right. Ms. Degrez, I can certainly understand, as I said before, the emotional impact that the request to leave the family home and the whole home that you've shared with your child for a long period of time, why that would have some emotional connection to you and why that would be difficult, probably economically, emotionally, socially. However, this is nothing more than a common, ordinary landlord-tenant matter. This is a holdover on a verbal lease, if you will. The parties mediated that as a part of the custody and parenting time portion of your relationship. That was reduced to an agreement. The parties with counsel agreed to have you move from the home on March the 31st. Mr. Dash and Mr. Blumberg are simply asking that the court now enforce that through the appropriate contractual landlord-tenant process. You have been given every opportunity to produce to me a landlord-tenant reason why I should not do that, why I should allow you to stay within the home for a longer period of time, and you've not given me any legal basis for doing so, other than it would be hard for you, it would be hard for the child, and you would like some grace. Unfortunately, I can't make one side agree to something that they do not wish to. The parties reached this agreement. I can only enforce what the parties agreed to, and that's what I'm going to do in this particular case. Mr. Blumberg, do you have a proposed judgment for me to sign today or not?
I do not, Judge. I will provide that to the court tomorrow, certainly at the earliest, or maybe later today. Although it's
all right. Why don't we do that under a 7-day notice? She would be required to be out within 10 days of today's date. That's the most time that I believe that I would normally be allowed to give her. So, ma'am, you have 10 days from today's date. Mr. Blumberg is going to send me the original and send you a copy of a proposed judgment. If you disagree with, not with what my ruling is, but what his order says, whether it if it differs from what I have said, then you have the right to object to it, and you must do so in writing. If you don't object to it, I will sign it in 7 days, and it will become the order of the court. Do you have any questions, ma'am?
Just, I suppose one, a lease would have been very helpful. The fact that there's not one, I think is a glaring oversight to all of it. Like you said, it's just one sentence. And I begged for a lease.
I don't disagree with you that a lease would have been very helpful, but it wasn't there, and I can't go back and change history. All I can do is base things on how the law typically works. There are lease agreements where nobody writes it down. It's not supposed to be that way, but they do that. People let people stay in their house all the time, and if they hold over after they've been told to leave, we do the landlord-tenant stuff. So it's not out of the question to have a non-written lease, and so that's what you have in this particular case: a non-written month-to-month lease. You're a holdover after you agreed to go. And so I'm treating you exactly the same way I would treat anybody else that comes before me with the same kind of claim. You have these rights. We went through the reasons why you might stay, and I found for the other side, and I believe that they are being upheld in the proper way to proceed. So all I can say is Mr. Blumberg is going to submit an order that comports with what I've said today. You have 7 days to object to that once you receive it. If you don't object, I'll sign it. If you do object, we'll have another hearing on it, but you've got 10 days period to be out. Okay? All right. That's all for today then. Thank you very much.
Judge, can I just ask one last thing? I want to make sure we all understand.
Yep.
Well, she has the right to object to the form of the order, but not the court's ruling. I'm not sure she understood that.
That's correct. And she has the right to appeal if she wishes, but she'd have to do that appropriately. And I don't know whether the next court would accept it or would adjourn it or hold it in abeyance. So all I can say is that's the ruling that I've made. Mr. Blumberg is going to submit the order, and we'll take care of things in the due course as they proceed on down the road.
Taylor Aikens.
I'm present, Your Honor.
All right, and I see Trooper Daniels is here. I'd ask both of you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, Your Honor.
All right. Okay, let's start with you, Trooper. If you'd go ahead, and then Ms. Aikens, I'll hear from you.
On April 7th of 2025 at approximately 3:30 p.m., I was sitting stationary on I-75 near mile marker 289. And this is in Otsego County, Corwith Township. I was facing northbound, observing southbound traffic. Immediately to my left was several workers that were cleaning up trees or debris from the ice storm. They were on the right shoulder with a move over sign, arrow sign, and I was observing traffic from southbound approaching their location. I observed semi-truck, log truck traveling southbound in the right, and then a vehicle, a white SUV that was in the left lane was in the process of passing the log truck before that location. The white SUV completed the pass and appeared to be traveling at a high rate of speed. I activated my radar unit, obtained a reading of 91 in the 75 zone. I initiated a traffic stop on the vehicle, made contact with the driver, she identified as Taylor Aikens. I advised her the reason for the traffic stop. She informed me that she was attempting to get around the log truck because she was coming in hot and didn't want to get behind the truck. I did issue a citation for a reduced speed of 6 to 10 over, and I did note that there were snow flurries that day. It was approximately 28 degrees. It was a straight road. There were no obstructions between myself, my patrol car, the radar unit, or the target vehicle. And the reading on the radar unit was consistent with what I observed as far as estimated speed.
All right. Did she say what she meant by coming in hot?
No. She just said that she saw the work. She did see the worker, so she sped up to get around the truck.
All right. Some places where there's work being done, the speed limit is less, but I take it there was not at this point. Is that correct?
No, there was no reduced speed limit. It was just they were on the shoulder with a arrow sign, and like I said, I was just sitting there running radar and attempting to help out with traffic to slow down and move over for the workers.
Did the work trucks have like a flashing light?
I don't believe so. They were red. I think there was 3 or 4 vehicles on the right shoulder. They were red in color, and they had a large arrow sign that was flashing to
All right.
get people to move over.
Okay. All right. Thank you. Ms. Aikens, what did you want to say?
Yeah, I guess I have a little bit different. What happened, I guess, was correct is what he's saying, but if I could just explain the day as well.
Go ahead.
I was going southbound down I-75 South. I was moving over for a log truck. I never told this officer I was coming in hot. I was still at an inclined speed because where he was sitting was right at the end of a tree line on that median. And I had just gotten up to, he had pulled me over at 90, but I was steadily increasing. And then after I had passed the truck, and it wasn't 4 or 5 trucks, it was one singular line truck. And it had the square on top of it, but the square on top of it only had a blinking line across it. It didn't say move over. It wasn't an arrow. They were just getting set up. They just pulled over. And so I was pulling over, but the problem I have with the situation is he's right. There were no other cars on the road, about one car every other mile or so. So after I got around the log truck and he turned over, I thought that he read the situation, understood that I was just getting over. So I got in the right-hand lane, put my cruise control back on. But this officer followed me directly in my blind spot for almost over 2 miles, to the point where there was a truck coming up in the right-hand lane, a mile ahead. And he stayed in my blind spot until I came up behind this truck, who can see the officer. So this truck now is going below 70 miles an hour. I slowed my car down all the way to 63 miles an hour. And this officer did not get out of my blind spot. He stayed there, even though it was safe to pull me over at any point in time. And he scared me. And so when he pulled me over, when we get to the side of the road, do you have any other questions? I tried to explain, why I was moving over, and he cut me off profusely. But when I asked him, I come from I just left my grandpa's funeral. Like, you really scared me. Why are you following me in my blind spots? He told me, I don't remember if he said it was a strange question in his 20 years or a stupid question, or it was a comment. And then said, if I have any questions, to take it up at this courthouse. So afterwards, I called the Gaylord State Police Post to try to ask them, because if that's, if they're supposed to follow you in your blind spot on the highway, then that's fine. But I just wanted to know that that's protocol to do to someone, because my whole body was shaking by the time he pulled me over. He followed me for a long time. And when I called the Gaylord State Police Post, it transferred me to a regional communications center where another gentleman answered. And as soon as I said that there was an officer in my blind spot, they hung up on me. And I tried to get dash cam footage to show that my speed was a steady incline. And I can't do that without an attorney. There's no body cam footage without an attorney. And I don't know, I was trying to do the right thing. It was one singular truck. It was a double log truck. So it wasn't just one semi-full, it was 2. So I didn't see that there was a truck pulled over on the side of the road until I was all the way through the first log, the first semi of logs. So I was just trying to do the right thing, but mostly I'm here today because, yes, I was speeding, but your officer really scared me. And he didn't want to tell me why he followed me for so long in my blind spot when I was just trying to do the right thing on a clear day. And so that's what happened.
Did you see, and maybe you said this and I missed it, did you see the work crew that was there?
I didn't see, there wasn't a crew. It was one singular truck. Truck with and I didn't see the truck until I was already passing the log truck, because it was blocking my view of the work truck.
Okay.
So when I got halfway up, the double pane, so I'm this far and I can see it right up here. So I sped up so he could get behind me, because they only, he was going 60, 65 miles an hour. But as soon as I passed him, I got in the right-hand lane. I went back to cruising 75. I went back to my music because I thought the officer, would have observed the situation and understood that I was just trying to move over. And instead, it absolutely scared me and left, I left the scene crying, wanting to talk to someone about why that would happen.
All right. Yeah, I wasn't there. I'm not doubting anything that you said. On the other hand, there is a speed limit there. This is not the world's most serious offense. And there's a couple things I want to tell you. I do have to find you responsible for it. The fine's $125. I will get back to that. But you have, I mean, and I'm not doubting you when you say this. I have difficulty believing that the other officer would have hung up on you, whether there's some phone malfunction or something, I don't know. But if truly you think that's a situation, I'm not recommending you do this, or I'm not recommending it. You can always file a written complaint. Also, if you want to get the body cam, you do not not the body camera, but the vehicle footage, and I don't know if they have it or not. Trooper, do you know, I know those don't activate until the lights go on. Would there be camera footage available of the time immediately prior to the stop? In other words, when you observed her, or not?
Yes, Your Honor. So I reviewed the video just prior to the hearing. It shows the log truck moving. It actually shows her in the left lane passing my location, and then the log truck moving to the left lane after she passed. And then it also shows that there were several work vehicles on the shoulder. And so all that leading up to the traffic stop. I also did explain to Miss Aikens that the reason that I followed her for so long is I was waiting for a safe location to pull her over.
Right, sure. And Ms. Aiken, just so you know, that's in the officer's call. He has to make that. If an officer is following you, there's natural concern there, but they're in a fully marked vehicle. But having said that, if you want to see the footage, there's a way to pursue that. You can add, this is called an informal hearing. You can request a formal hearing, and the way you do that, if you decide you want to, you would pay the fine, which goes into an escrow account, and ask for a formal hearing, and you have to do that within 10 days of today's date. And at that point, you can call the prosecutor's office because they become involved there, and you can get an attorney if you want. I realize it's probably not worth it for $125, but if you want to see the footage, that would be the way to do it. You can also make a Freedom of Information Act request to see it. I mean, the officer said he just reviewed it this morning. I have no reason to doubt him on that, but if I was you, I'd probably want to see it myself. It's just human nature. So I will find you responsible. The fine is $125. Are you able to pay that today, or will you need some time?
I can pay that today. And then,
Okay. Let me say one thing about that and hold your thought. You actually can't pay it today just because the clerk who would take it isn't here. If you could call tomorrow afternoon or the day after, that would be fine. But what were you going to say?
and where is it, do I file the formal complaint at?
Well, I'm not telling you to file a formal complaint or not. If you're talking about the formal hearing, that's just, I'm sorry, which one are you referring to?
Sorry, not the formal hearing. You said if I wanted to file a formal complaint with the police post, where do I file?
I'd probably find something online, Michigan State Police. That's out of my jurisdiction. That and I'm not suggesting to do it or not do it, but that's there. If you want to see the footage, you can do it by either setting for a formal hearing, which would just be a rehearing of this in front of a different judge, or making a Freedom of Information Act request.
All right, thank you so much.
All right. If you're ready, I'll give you the phone number to call.
I'm ready. I think I've got it written down from the hearing before this, but I can take it again if you'd like.
989-731-0201.
Perfect, I've got it. Thank you.
Okay, all right, thank you very much. Trooper, do you have any other cases, or is that your last one?
I believe that's the only one, Your Honor.
Okay, thank you then.
Have a good day.
Okay, so the first woman so badly wanted the judge to feel sorry for her. She was trying so hard to get him to feel sorry for her. In fact, she repeated over and over how he's dangerous, and she's terrified, and he's scary. He's a scary man. Well, then why do you live in his home rent-free? Why don't you move? And she says, oh, well, we don't have anywhere to go, and, we could become homeless. Well, what about your mom's? She said she went to her mother's one other time, so why don't you go back there? I just don't like this B.S. that she was just spewing. She was pathetic. in my mind, she was pathetic. She can't help herself. She can't do anything to help herself other than cry and complain and say how scary he is and how she has to be protected. Well, why don't you move? Moving might protect you a little bit more than being in his home rent-free. Don't you think? So, I think she was ridiculous. Same with the second woman. Young girl. Young woman. Very young woman, I should say. She was also pathetic. That's what my opinion. Anyway, saying, oh, he was following me. This police officer was following. Yeah, he was following me. He was trying to pull you over. And sometimes they want to get up close enough so they can see how many people are in the car. Because if it's loaded down with a bunch of people, he might need backup just to help him handle the whole thing. So that might be a reason why he was getting so close and why he was in your blind spot. But she was also pathetic. Anyway, thank you guys so much for watching, and I will see you another time.